Right, well, welcome everybody to this Adjudicating Rights conversation. We're particularly delighted to welcome Manuel Cepeda, who was served as a magistrate on the Constitutional Court of Colombia from 2001 to 2009 and as president from 2005 to 2006. I think I first met Manuel in about 2007. And the South African Constitutional Court, of course, and the Colombian Constitutional Court have often been compared. So we've had an ongoing dialogue in the time since then, and I've always found that I learned an enormous amount from him whenever we met. Before his appointment to the court, Manuel was advisor to the Colombian President Trujillo for the Constituent Assembly of Colombia, which led to a new constitutional settlement in the early 1990s. He has law degrees from the Los Andes Law School in Bogotá and also from Harvard Law School. And he has basically crossed between practice and policy making and academia all his life. Had a period as dean of the law school in Los Andes Law School, but has also, as I say, been involved in a variety of different ways with the constitutional project in Colombia. Most recently, of course, in relation to the peace process, about which he'll speak more tomorrow evening. Since his term on the court ended, he has combined academic activities with a range of other engagements, and so he is currently serving as the president of the International Association of Constitutional Law, and tells me, in fact, that he's just come from a meeting of that association in Rome. We're also very fortunate to have Octavio Ferraz and Sandy Fredman, both of whom are experts in comparative constitutional law and comparative human rights law, and both interested, I think, as I am, in the particularly special nature of the Colombian constitutional project. So we're very grateful to them for agreeing to participate in this conversation. We'll run it with a series of questions to Manuel, who's also indicated if there are points of clarification you want to make, especially because we're a small audience, please do feel free to intervene as we go along. But it is meant to be a sort of an informal opportunity for us to ask all the questions we wanted to ask about the Colombian Constitution, but we're often unable to do so. So thanks very much. And Manuel, I thought I might start off, because it's a question I'm often asked, as to how it was that I ended up becoming a judge. And perhaps you might, I've sort of given a very brief sketch of your career up till now, but perhaps you might just give us a fuller sketch of that and how you ended up on the Colombian court.
Thank you very much. I am so pleased to be here, Kate. I want to thank you also for your participation. And thank you, all of you, for coming to listen to the Colombian experience on constitutional adjudication. Well, I was always involved in constitutional law. As you mentioned, I had participated in the constituent process in Colombia, and I had fought for the creation of a constitutional court in Colombia. We had a Supreme Court that had exercised judicial review since the end of the 19th century. So the creation of the constitutional court was a very hot issue in Colombia. But the government that pushed for the Constituent Assembly also pushed for the creation of a constitutional court. I had worked in this government. So I was, in a sense, associated with the idea of the court. But then I went abroad, I came back to academic life, and the moment arrived in which the court had to be renewed. 8 years had already passed, and the President of the Republic at the time decided to send what is called a mixed list of candidates. So there were conservative candidates, very liberal candidates, and let's say liberal independent. I was one of them. Not many chances of being elected. I was not the favorite of the list because I was very young at the time, and there were very important jurists in the list. But in the end, a coalition formed, and I was elected to the court. So I would say it was my past activities and a lot of luck.
Thanks very much. Octavio.
So you've been closely involved in the process of constitution making in Colombia. You mentioned already the creation of the Constitutional Court as one of the important things that this new constitution has done. What about other institutions have there been other important institutions that were created in that constitution, as well as was the case in other Latin American countries? And what about new rights? Were there new rights included in the constitution which weren't there before?
Before, yeah. So in 1991, a democratically elected Constituent Assembly approved a new constitution. And this constitution wanted to break with the past. Our past was a past of a constitution that was very presidentialist and that had faith in a strong figure that would establish order in Colombia and protect the citizens. It didn't happen. We had armed conflicts during decades. Rights were not effectively protected. The country was governed by a state of siege, and the drug cartels flourished and were very powerful in the 80s in Colombia and were really challenging the state. So in 1991, what we had was a new constitution whose main aims were to strengthen the judicial system, and that's why the Constitutional Court was created, but also the office of the public prosecutor. And this office of the public prosecutor, modeled in the American system, but with important variants, had the mission of building cases against the powerful drug cartels. And during the 90s, this office managed to do that. The two main cartels were dismantled, either because the drug lords were killed or put in prison or extradited to the United States. And so these were the two big changes in the judicial area. In the question of rights, in 1991, a generous Bill of Rights was adopted with all kinds of rights. We called them at the time the 3 generations of rights. So we had basic civil and political liberties, then socio-economic rights and cultural rights, and some 3rd-generation rights important for Colombia. For example, the right to peace in a country that has a lot of violence. So, and this Bill of Rights, being Colombia a country in which laws said something, but the promises of the Constitution never were really implemented, never delivered to the citizens, the Constitution also created mechanisms to implement rights. And the Constitutional Court was, of course, a key one, but there were others. So the office of an ombudsman was created, called Defensoría del Pueblo in Spanish, and new judicial proceedings were established, mainly acción de tutela, which is a form of amparo. It could be translated as a writ of protection of fundamental rights. This writ of tutela, we may address it afterwards, but was a very important instrument to make fundamental rights effective and effectively implemented in practice.
So you've talked quite a lot about the Constitutional Court, and what's really striking is you say you wanted a break from the past, and that's quite similar, I guess, to what's often said in South Africa about the new constitution, a break from the past. And you talked about how important this Constitutional Court was. So I wonder whether you could say a little bit more about the court. Clearly it had to adjudicate a whole lot of different kind of rights, like socioeconomic rights and rights to peace. Did this change in some ways the role of the Constitutional Court and the judges on the court perceived itself as playing in relation to political and social forces, particularly with the tutela and the much greater access, as I understand it, of people from disadvantaged backgrounds to justice, which is very different from other systems. So I wonder whether you could say a bit more about what that meant for the court, how the court perceived itself as the role it played in society in bringing about this social transformation.
Yes. Well, the court was created after a bitter debate in the Constituent Assembly. Really very few parties in the Assembly wanted to create a Constitutional Court, but finally a majority was gathered. Why? Because the members of the Constituent Assembly had to solve the following question. To whom would you entrust the defense of the new constitution you are creating? And so they decided that a new organ should be entrusted with this function. And secondly, the Constituent Assembly wanted to break with the past and transform the present, to create a new future for Colombia. The new constitution was approved under two slogans. The Constituent Assembly is the way, is the path, and the second, there will be a future. And the court then had the mission of helping in the transformation of reality. So Colombian constitutionalism can be linked to transformative constitutionalism, as has been the case in South Africa and other countries. And transformative constitutionalism meant for the court, first, that it could not shy away from difficult problems. So, in the beginning, there was a case concerning the constitutionality of the Concordat, the treaty with the Vatican, in a formerly Catholic country. The court couldn't shy away, had to decide on whether the Concordat was constitutional or not. There were cases concerning indigenous peoples that had never accessed a high court to ask protection for their rights. The court couldn't shy away, had to decide. So, with time, the court had to tackle very tough problems and to implement, that's a third very important point, to implement constitutional clauses that were transformative in their language. So, for example, the equality clause in our constitution is not just a clause that says that everyone is equal before the law, or that everyone has equal opportunity or has equal protection. Of course, the clause says that. The clause also forbids discrimination and enumerates the grounds on which discrimination is forbidden. But the equality clause goes further and says that there should be protection for those that are economically weak, or says that equality should lead to the end of exclusion and marginalization. And so therefore the equality clause contains mandates that are transformative of reality and that have a substantive content. One can say the same of other classic clauses. Let's look at religion. The Constitution says that there is freedom of religion, of course, freedom of conscience, but it also adds that all churches and religious confessions are equal before the law. So you have a Catholic country that had a concordat, and you have an equality of churches. What do you do with this clause as a judge? So, and of course, social rights. Everyone shall have access to health. Everyone shall have access to a dignified housing. And these kind of clauses led the court to interpret in hard, complex problems a constitution that was transformative. We should add to that in Colombia, access to the judicial system for constitutional litigation is very open. To sum it up, in 1991, we got rid of the lawyers. You don't need a lawyer to access the courts, to seek protection of your rights. So there was an explosion of litigation through very informal procedure called tutela. And therefore, the court was in a situation in which there was a constitution that was progressive, transformative, and promised a lot of things. There was a reality that didn't fit this constitution. The gap between the two was very wide. but there was a bridge, tutela. There was another bridge, Actio Popularis, and people could walk this bridge without the hand of a lawyer. This created such a pressure on the court that the court had to decide a lot of cases, and in this way, the court became a lead actor in the transformation of Colombian society and politics. This is accompanied with what I call the failure in the transformation of the political system. So there were new electoral rules adopted in 1981, but the political party system didn't change as fast. So the coalition that adopted the constitution in 1981 dissolved, and there were new parties and old parties that regained political power. So the political process was not the force that implemented the constitution. It was the judicial system who had to implement the constitution. And this gave to the court a very important role. In Spanish, we say, el revolcón lo hizo la corte. This means the upheaval was done by the court, not by the politicians.
Okay, so this is all about the new constitutional court, right? But if before we discuss more about it, which I'm sure we will, could you go a bit to the past as well? There was already an apex court in Colombia, right? The Supreme Court. And it's quite unusual for a system to have two courts, perhaps competing at the apex of the system. So two main questions. One, was the record of the Supreme Court not that good in terms of rights and transformation? And secondly, has it created tensions, a conflict between the two courts, the creation of this new court?
Yeah. The Supreme Court was the de facto constitutional court since 1886. Our Marbury versus Madison was in July 1886. So it was a court with a 100-year tradition of judicial review. The court rendered very important decisions, but in the balance, the court didn't push for the implementation of important clauses in the Constitution that had generated hopes at the moment they were established. I give an example. In 1936, there was a very important constitutional amendment that introduced social rights in our Constitution, and that established that private property had a social function. The Supreme Court did not interpret these social rights in a way the political process expected and citizens expected. It was considered a court that slowed down the process of transformation. Then came other very important moment, which was a moment of reform of the judicial system and the political process and the structure of the state. There were amendments to do that, and the Supreme Court struck down these amendments. So we had unconstitutional constitutional amendments since 1979. So the Supreme Court started to be perceived as an obstacle to change. And thirdly, since Colombia was governed mainly by a president that used state of exception decrees, estado de sitio, state of siege, the court didn't work as a check on the president. It usually supported the very drastic measures of the president. Nevertheless, it was a respected court with a 100-year tradition. So the Constitutional Court was not created against the Supreme Court. It was created in favor of a new vision of judicial review, what was called new constitutionalism at the time in Colombia. Clashes, yes, a lot of clashes. The Supreme Court opposed the creation of the Constitutional Court, but politically, since the court was not created against the Supreme Court, in the end, the Constitutional Court was created, and was cautious at the beginning. The main source of clash has been tutela against the decisions of the Supreme Court. So, as happens in Germany or in Spain, the judicial decisions of the highest court, in this case the Supreme Court in labor, criminal matters, civil matters, commercial matters, the Supreme Court decisions can be challenged on constitutional grounds, and the Constitutional Court renders the final decision. And so the Supreme Court was not supreme anymore and didn't like that. We had this battle of the courts for a long time. The Constitutional Court tried to manage the situation. And now, let's say from 2007, there has been a kind of peace treaty between both of them. And this peace treaty was a result of a lot of factors. I will not go into them. Occasionally, there is a decision of the Constitutional Court that revives these agreements. But I would say that now there is a compromise.
Just to complement, could you say a bit about the appointment of judges and the terms of office, whether they are different in each of these courts?
Yeah. So the Supreme Court, both courts have 8-year terms. The individual 8-year terms for the justices. But the Supreme Court is elected in a way that we call it partial cooptation. So the Supreme Court elects the justices of the court, but elects them from a list of candidates sent by a judicial organ who is in charge of the administration of the judicial branch, el Consejo Superior de la Judicatura, the Superior Judicial Council. So politicians cannot participate in the election of the Supreme Court, and the terms of the justices are individual. The Constitutional Court is elected by the Senate. The Senate is in turn elected in one national district in whole Colombia. But the Senate cannot select the justices the Senate wants. The Senate must pick one per each seat in the court from a list of 3 candidates. So there is an election between 3 candidates for each seat every time. There are 9 justices in the Constitutional Court, and 3 seats come from lists from the President of the Republic. 3 seats come from lists of the Supreme Court, and 3 lists come from the Council of State. So in a sense, it is impossible for the President or the Senate or the Supreme Court or the Council of State to get a majority of the court. It's impossible because no one can elect freely 5. All are bound by the other. So it's an internal system of checks and balances that was created in anticipation to the most common evil judicial review must face, which is the attempt of the political forces to pack the court. History shows that in the United States, in Europe, all over, there is an attempt to pack a court. And so the design for the election of the justices had the purpose of avoiding court packing, knowing that there will be an attempt to pack the court. Until now it has worked. Let's see how it works in the future.
Thank you.
So you've been previously known to say that the Constitution was primarily drawn up in order to achieve peace in Colombia, and I gather that also means social peace as well as other peace, civil peace. And I wonder whether you could say something more about that, and particularly the role of the Constitutional Court, if at all, and the role of the judges on the court in advancing this particular role of the Constitution.
Yes. In Colombia, constitutionalism conflict and peace have been tied together always. So we have easy access to the Constitutional Court as we had easy access to the Supreme Court through Actio Popularis since 1910. And this was adopted because of a transition. We had a fight between one party that controlled, other party that was in the minority, a very authoritarian president. And in this transition, proportional representation was introduced to give more space to minorities. And Actio Popularis was created as a way to say to the citizens, if you are angry with an unjust law, you don't have to kill the members of Congress. You can go to the court and say, this act of Congress is unconstitutional. If you want, it was a way to judicialize civil disobedience, to channel through the judicial process. And so this is one of the first functions of the Constitution and peace building in 1910. It worked for a while, but it was totally insufficient because of different factors. But I would mention the most important one is that with time, the Constitution and the basic institutions lost legitimacy in Colombia. So when the Constitution was adopted in 1991, Colombians answered to this question the following way. They were asked, do you think that change in Colombia can be achieved through reform, only through revolution, or do you prefer the statu quo? And half Colombians responded, only by revolution. So it showed that the legitimacy of these institutions was really compromised. So the second purpose of the constituent process was to strengthen the legitimacy of democratic institutions. To win, if you want, the ultimate battle, which is the battle of legitimacy. And until now, it has worked. Of course, institutions sometimes go up and down in popularity. The presidents are more or less popular. But the peace process with FARC, it was achieved at the end of last year, FARC is a main guerrilla movement, is a peace process in which the guerrilla had to accept the Constitution and had to recognize the Constitutional Court as the ultimate interpreter of the peace agreement and the legislation to implement the peace agreement. It's a hard test that a 50-year-old guerrilla enters the constitutional system and recognizes the Constitution and the court. But then in the middle, there is social peace. And the court has been very active in the protection of social rights and the protection of minorities and marginalized groups in a way that it's aimed at including them in the benefits of Colombia's progress. So, tutela for social rights, for indigenous peoples, and for different minorities and vulnerable groups can be, in this perspective, be conceived as an instrument of inclusion, and in this way, an instrument of appeasement in a context in which there is violence. And finally, tutela also worked as an instrument of peace building, case by case. So in Colombia, you have the possibility in practice of asking for something judicially, politically, or violently. As the political process fails, there is a choice of going to violence or going to the judicial system. So tutela is a way of resolving conflicts through peaceful judicial means in a violent context, in a context where violence is not something possible, but is something actual and present. So in this way, tutela has been also an instrument of peace in society.
Just interrupt on that for a second. So would you say that back as far as 1990, in the process of constitution making, a major part of the audience for constitution making were the guerrillas?
It's also very important, yes. So in 1990, there was a peace process with the M19, which was an urban guerrilla, very active, not as big as FARC. The peace process ended, and it coincided with the Constituent Assembly, and the M19 run for the Constituent Assembly, got a lot of delegates to the Assembly, and one of the three presidents of the Constituent Assembly was a former leader of the M19. So in this sense also, the constituent process was linked to the consolidation of peace with the M19. There was also a very important, another important guerrilla movement that made peace because of the constituent process, which was the EPL. This armed group demobilized after the assembly had been elected and had the chance of appointing 2 members to the assembly that could not vote, had only voice. After the assembly was elected, 4 guerrilla movements demobilized. So really, the constituent process led to either the consolidation of peace with the M19 or the demobilization of other guerrilla groups. FARC didn't go in, and ELN didn't go in. Now with FARC, we have a peace agreement. With ELN, there are conversations going on in Ecuador.
I want to bring the discussion back a bit to the idea of social peace, which I think is quite interesting. So in most democracies, social peace is achieved or attempted to be achieved through public policy. And public policy usually implemented by the political institutions, the democratic institutions of the state. You've been talking a lot about the judiciary as being the important new element in Colombia to avoid revolution, to avoid social unrest, so to speak. So this series focus is separation of powers in different legal systems. I was wondering whether you could say a bit more about whether you think that this separation of powers that seems to be prevalent in Colombia, where the courts have a lot of power, is adequate, not only in general, but for Colombia in particular, the context of Colombia, and also to expand a bit on the powers of the court vis-a-vis the other institutions. You've mentioned already 2 interesting aspects of the separation of powers, which is the appointment of judges, which is quite unique, I think, to Colombia, and also the term in office, which is quite short, I think, compared to many other places, but you haven't said much about the powers of the judges. Is this quite extended, or are there limits as well to what they can do against decisions of the political branches?
Yes, a very tough question. Of course, social peace can not only be achieved through judicial means. It's too much a task for the judiciary. But the judiciary can contribute. And what we have in Colombia, of course, are social policies adopted through the political process, through social policies designed by the regulators. This has worked. But the problem is that after there has been an initiative of the political process and the regulator, in the implementation, there are huge failures. And in the follow-up and the redesign, there are huge failures. So we have, if you want, social policies that are key, very important, but that have 2 big problems. Are these 2 big problems solved through the political process? Sometimes they are. But when they aren't, there is a big issue, what to do. And there, in this space, the judicial system in Colombia has contributed to social appeasement. So one can say that it's in the beginning it was marginal. It was only when the regulator failed to fine-tune a social policy, for example, it was marginal. Or when a problem of design was present and the court intervened, and so the political actor reacted. But that's it. Then came something more structural. And in what is more structural, the court rendered orders, and I go to the second aspect of your question, orders that were very harsh against basically the executive and sometimes the legislature. So in Colombia we say that the court has freedom of remedies. The court can design whatever remedy is needed to solve the constitutional problem and obtain the effective enjoyment of the constitutional right at stake. For example, the court can order that a policy be designed or a plan be adopted. The court can go further and order that an estimate of the resources needed to implement the plan should be made public. If the money is not available, the court can say you must establish a plan to raise the money, or say that you will not continue protecting the right and diminishing the protection of the right. So the court has freedom of remedies in tutela, and in abstract judicial review, the court can also modulate the effects of the decision. The court can intervene and say, this is unconstitutional, but nevertheless the law will be applied and we will give time to the political process to correct the law. So it has freedom of remedies to... That's important because, in a sense, the court is activist, but at the same time is prudent. One can speak of prudent activism. The court does not replace the regulator. The court does not redesign the social policy. The court does not create a law, but the court intervenes and remands to the political process or to the regulatory process within a framework, and therefore generates a dialogue, generates an exchange with the other branches of government, and this exchange then has results, sometimes better than others, but this exchange has results. In a sense, one can say that the court does not impart orders as managerial structural remedies used to be in the US. It's not an order of management of prisons. No, the court intervenes, of course gives orders in the weak sense, orders that unleash a process of dialogue, expertise, discussion. So it's a different approach. I say that is, in a sense, responsive constitutional adjudication, because it looks at the problems and tries to give an answer to them based on the Constitution, but is also empowering constitutional adjudication, because the actors, including sometimes the executive, are empowered to take decisions that otherwise wouldn't have been taken if the court had not been intervened. So it's not a judicial review that demobilizes social movements, but that generates social movements. It's not a judicial review that suppresses the role of the regulator, but that stimulates the regulator to act. And I could continue highlighting the contrasts. And if you want afterward, we can look at concrete cases. But I would say that if we have to pick three labels: transformative constitutionalism, responsive constitutional adjudication, and empowering judicial intervention with prudent activism. It's strange, but it is the way it has worked.
So this is a really fascinating description of the court, because people are often divide courts up into activists interfering with the executive or passive, being deferent to the executive, and this idea of the court as facilitating and dealing with poor governance by remobilizing is extremely interesting. I wonder whether you could say a little bit more about the role of other social groupings, civil society, the middle classes, academics, how important that's been to give the court legitimacy in its relationship with the executive.
Very important. As the court intervened, the court generated allies. Is not, I would say that in Colombia, Colombia is not a case of civil society organizations doing a strategic litigation and gaining a case, winning a case. This has happened, but afterwards. The beginning was the court intervening, making decisions that stimulated organizations of civil society to support the decision and to develop further what the court had done. These gave rise of new or strengthened social organizations that support the court from a wider spectrum. We had all kinds of. We have indigenous peoples supporting the court. We have persons that lost their houses because of a mortgage crisis that went to support the court. We have same-sex couples that support the court. We have women's movements that support the court. But this happened at the beginning because the court was perceived as responsive. So basically the citizens said, okay, this court listens. We may move. We may go to this court because the court listens. But, of course, as the court listened, others reacted. And so this created movements and organizations to defend what happened. For example, when I was at the court, there was a constitutional amendment to curtail the powers of the court, concerning the protection of social rights, and to curtail the power of the court to make these kind of structural interventions. And I remember that the court was surrounded by citizens that wanted symbolically to say to Congress, which is in front of the court, stop! You shouldn't come to hurt or to diminish the powers of this court. Even indigenous peoples that walk from far away to Bogota, the capital of Colombia, to protect symbolically the court. So there is this close relationship. I wouldn't call it an alliance or a pact, because the court is independent and sometimes render decisions that make these movements unhappy. It's normal. But in the whole, the court is perceived as somewhat that listens and sees. You have to take the image of justice in Colombia. Justice is not a woman that has a bandage, but justice is a woman that has taken the bandage away and can see reality and can react to what is happening in reality. So it's another vision, and this generates in the citizens a hope and expectations, and stimulates them to organize to fight for their rights or defend the rights the court has already recognized.
So just to follow up on that, David Landau, as you know, has written his thesis on the court and has suggested that this in fact has been something the court has cultivated, this support, and one sees some similar comments made about, for example, the Indian Supreme Court, this idea that the court has become a political actor partly to preserve its, to protect itself. And Tienes Rue has written on this as the kind of the pragmatics of how a court works. Do you think that's an accurate description, Or do you think that actually this is just something that happened as a result of the way the court responded or the way people responded to decisions of the court?
Well, I know David Landau, we have published a book together, we are close friends. Of course, the key word is cultivated.
Yes.
I think that there hasn't been meetings or pacts, no, this kind of thing. But I would say that there has been a coincidence that is an easy coincidence, because if the Constitution promises equality for women, and the court applies this clause, women organizations can say, okay, we are in the same direction. There are moments in which the court is, let's say, more cautious on how fast it should move. Or, on the contrary, sometimes the court goes too fast, even against the expectations of social movements. For example, when I was already outside of the court, I had a meeting with the most important organization that promotes the rights of same-sex couples. And the court had to decide on marriage of same-sex couples and adoption by same-sex couples. And the leaders of this organization wanted to meet with me to ask me, what shall we do? We do not want the court to go as fast. We are happy with the protection we have received, but there are individuals, since access to the court is so easy, there are individuals that go to the court and put the issue in front of the court, not these social NGO or social organization or NGO that usually litigated in favor of same-sex couples. So it's very complex. What the court decided in these two cases was to protect same-sex marriage, formally applying the civil code. I will go into details if there is interest. And then it accepted adoption by same-sex couples in certain limited conditions. And this created a backlash. And now there is a referendum going on in Colombia, an initiative for referendum, to introduce in the constitutional clause establishing that only heterosexual couples can adopt. And Congress had to decide today whether, in the third debate of the 4 debates needed, they will approve a referendum on this issue. So it's a very complex thing, but I would,
Thank you.
Yeah, I would like to go back to the issue of tutelas. You've mentioned already that it is one of the most important new things of the Constitution. In the answer to the question now, you said already it's so easy to go to the court. So we don't need lawyers. We let the lawyers at a distance. But you mentioned in this answer that there might be also problems, right, with this easy access to the court. So I wanted to explore another issue related to that, which we see a lot in other Latin American contexts. And I wanted to know whether the tutela being so accessible still doesn't create the environment that the most disadvantaged individuals need to litigate effectively. And that happens here in the UK as well. You don't need a lawyer to go to the courts, but if you don't have one, you are more likely to lose or not to present your case properly. So two things here. Firstly, rights awareness is usually as big an obstacle as having a lawyer to go to courts than legal representation. And the second is, isn't there still an advantage of people who can pay for a lawyer to go to courts in comparison to those who cannot?
Yes. I share your concern. I think that poverty has an economic dimension but has several other dimensions. And one of them is, of course, awareness of rights and the possibilities to access the judicial system or the political process to claim protection for rights or to promote interests. So I share it completely. So poverty is really inequality in several dimensions. But I would say that tutela in Colombia has been used by the middle classes and also even by the government. Tutela is introduced by the government. But in the whole, it has favored, I would say, low middle class and sometimes poor people. The numbers indicate that there are 600,000 tutelas in Colombia per year. 600,000. So we are already in a situation in which most Colombians have been favored or affected by a tutela, because if you add it in more than 25 years, of course there were no 600,000 the first year, is now. The first year there were only 10,000 tutelas per year. Why this explosion from 10,000 to 600,000? Because everyone can go to the court without a lawyer and without, which is very important, without a legal argument. Because in tutela, you can go to the judge, any judge in the country, and say, this is my situation, I feel treated arbitrarily. That's it. You don't need a legal argument. And the judge will then look at the situation and say, aha, perhaps here is a problem. So to go to an extreme case, two extreme cases. One, a young girl, a 7-year-old girl, I think, in the school was forced to cut her hair. And the girl refused and said, why are you going to cut my hair? I love my hair. It was a poor school. It was not a middle class school. And a tutela was filed, and the girl won against the authorities of the school. She had the right to wear long hair. Why her hair was going to be cut? Because of animals in the hair. Yes. I don't know the name. Yeah, lids. Okay, there is another way to cut totally your hair. Well, I mentioned another case which I had to decide. There was a very, an old man, very poor, that lived in the street. And this poor man went to hide under the external roof of a house. And there he passed the night. This poor man got very ill. He was a beggar. He didn't have access to the health system. But he wanted to tell in the Constitutional Court. Why? Because the owners that lived nearby said, poor man. So they submitted a tutela in his name. And the Constitutional Court intervened and said, here we have a situation in which there is a loophole in the health system. This person is not protected. And order the protection of the health of this very poor citizen. But having said, of course, internally displaced persons, we have in Colombia, because of the armed conflict, a lot of internally displaced persons. A lot means 3.5 million in 2004, when the court intervened, more than 3.5 million now, or 5.5 million now. The court intervened to protect IDPs. I don't go into the details of the order of the court, but basically IDPs are peasants, very poor, that had to flee the place where they lived and go to cities and become beggars in the cities or try to find ways to escape from the poverty trap. And the court intervened to protect all of them, past, present, and future. So there are interventions of the court that are aimed at the very poor, at the indigent.
Do you want to ask questions? Or should we carry on?
I think we might. I think there's just one issue that would be quite interesting just to talk about, and that's the structural reform of the healthcare process.
Yeah,
do you
okay.
want to follow up on that?
Okay. So I think this is really fascinating because in this country, access to justice has been progressively closed down. And as you might know, with imposition of fees to go to tribunals and the cutting of legal aid, access to justice has just been entirely decimated in the last 2 or 3 or 4 years. So for some of the people here to know that there is this tutela system where anyone can go and which really does apply to the poor is something very, very extraordinary, I think, and fascinating. But I wonder whether you could say something about, does it create some kind of chaos? So many people are coming with their individual claims about some particular issue through the tutela system, and a whole lot of judges all over the place are making decisions that this person should have this health care and this one should have that. And as I understand it, this did happen with healthcare system in Colombia, so that there were so many claims. It was distorting the health budget to some extent because the court kept ordering individual remedies, that this person should have this drug and this person should have that, until eventually the court pulled all the cases together and came up with a broad structural remedy. And I wonder whether you could say more about that, because again, coming back to your original point about whether the courts are making policy for the executive or whether they're facilitating the executive to make its own policy. Some people would criticize that by saying, on the one hand, the court was interfering by fragmenting all these little decisions, but then on the other hand, it was interfering even more by telling the executive what its policy should be. So perhaps you could tell us more in the context of the health system.
The health system, yes. So health litigation started in Colombia very early in the 90s. And there were individual tutelas, basically, I would say, middle class or even well-off persons from the contributory system. We have a system that is called contributory, another that is subsidized. The contributory system is for those that have capacity to pay and contribute. The subsidized is for the very poor. So most tutelas were, as you mentioned, individual cases to have access to medicines or to treatments or to diagnoses that were not included in the health plan, or were included, but perhaps the very specialized drug was better than the generic. And so we had this kind of tutelas that exploded and that led to an unlimited expansion of the right to health. But because basically in each case, what the judge did was ask whether the physician had ordered the medical treatment, and if the physician had ordered it, look at whether it was in the health plan. If it was in the health plan, it said, well, why isn't the treatment being provided? And it was a discussion concerning whether the treatment ordered by the physician or provided in the first plan, which was better. The judge, well, usually said, well, it's the physician who controls. And therefore, then the judge asked, do you have capacity to pay? And if the person didn't have capacity to pay, as happened with very expensive drugs or treatments, the judge protected the person. So gradually, the right to health started to expand without any limits. It had bad impact in the system, very important beneficial impact at the individual level, but a bad impact in the system in several ways. And most of the litigation was, I would say, middle class. In the structural decision you mentioned, which was rendered in 2007, the court said, excuse me, T760 of 208, yeah, excuse me. So in this case, the court imparted a structural order that tried to address these problems. How was the intervention of the court? The court said, first, there shouldn't be a separation between the health plan for those that have capacity to pay, basically employed middle class, and those that are poor. The health plan for the poor was half the health plan for those that had capacity to pay. And so it was separate and unequal, as in Brown versus Board of Education, that were separate but equal. Here were separate and unequal on poverty grounds. So the court said, concerning the right to health is inadmissible. First order to the government, you should look at a way to have a unified health plan that applies equally to everybody. You have to redesign the plans, do it, but in the end, you must have basic health for everybody in equal footing. Of course, this is an intervention, a strong intervention, but gave delays so that the government and the regulator could manage what to do there. And this intervention tried to protect the very poor, who did not access with tutela as often as the middle class. Secondly, the court ordered that the health plan be designed taking into account epidemiological studies so that the needs of the people were really included in the health plan. It's an intervention, of course. Perhaps the regulator was very angry because why the court will tell the expert to look at the data, the epidemiological studies. But the court didn't invent what were the needs. It said, you should look at that and give reasons on why you pick these or not, scientific reasons. Third, the court ordered that the health plan should evolve as the needs evolved, as new technologies were adopted. And so the regulator should be attuned, should be active, could not be passive waiting for years to see what to do if the needs change and technologies changed. And additionally, the court ordered that the redesign of the health plans should be participatory, so that the medical community, the organizations of patients, the economists that were concerned with cost, participated in the redesign of the health plan. And finally, as a precaution, the court ordered that the new health plan should be fiscally sustainable. So, basically, what we have here is an intervention that, of course, leads to a huge reform in the health system that would, we hope, favor the poor, but at the same time establish limitations on what can be done, because it should be fiscally sustainable and should be based on scientific epidemiological studies and should listen to what the physicians think is reasonable medical evidence. So it's an intervention that tries to address macro issues, protects the right to health, but allows for the establishment of limits, because there was an unlimited expansion of the right to health if you looked case by case. In practice, this led to a bitter battle between the court and the executive. The executive at the time said didn't want to proceed, that the court had created chaos. Then the executive did some moves, but decided to declare state of emergency. State of emergency. I was out of the court by the time the state of emergency was declared. The new court struck down the state of emergency for different reasons. One very important clause was that people could have access to health as long as the budget allowed to finance the additional costs in excess of what was established in the health plan. So basically the health plan, but any addition to health plan had a limit, and the limit was a budget that was defined at the beginning of the year. If by mid-year the budget was out, the fund was out of money, that's it. Different kind of clauses that the court said, no, that's unconstitutional. A new government arrived. The new government also was very angry with this decision, but with time started to evolve. And now, to make a very long story, not as long as my answer, basically now we have one plan that is common. So the plan for the poor is now equal to the plan for those that had contributory capacity. There was a tax reform that included new budgetary resources to finance these health plans. There was an intervention by Congress that approved a new statutory law concerning the fundamental right to health, defined as such by Congress. So the Congress followed the court, the fundamental right to health, and there are lots of provisions in this new statute that are slowly being implemented. So there has been a huge change, but on the other hand, individual tutelas continue, because the regulator has still to move in other aspects that will demobilize individual tutelas.
Anything further?
Do you want to open, or should
I
we
think it would be
continue?
good to open at some stage, and perhaps now is a good
Yeah.
time. I think we've had a really very interesting debate and discussion, and I think you've given us a great picture of the Colombian constitutional system. So I'm sure that there are many people out there who've got questions, because it certainly creates a lot of questions for those of us who come from different constitutional systems. Yes, Helen.
Thank you so much for this very fascinating discussion. I have many questions, but perhaps there's one I'm really interested in the way that you spoke about freedom of remedy. And I'm wondering if you could just talk specifically, first, perhaps descriptively, how is that formulated in the Constitution? So what is the textual framing of that freedom of remedy? And how might it differ from other formulations in other jurisdictions that you might be aware of? And then secondly, given that broad freedom, how has the Constitutional Court chosen to exercise that? Particularly, have you ever been in situations where the court is faced with a number of possible remedies that could be given, and how do you go about making that choice? And perhaps a question that kind of relates to that, has the court quite explicitly, do you think, tried to be quite imaginative in the remedies that it gives, trying to kind of think out the box, so to speak?
Okay, thank you. Well, in tutela, the freedom of remedies is developed in the statute that regulates tutela. The Constitution just says that the judge, the tutela judge, may impart an order of to do or not to do. So this is general. And then the statute says that the judge may impart any order needed for the enjoyment of the right. So it's really a very open clause. Mm. Of course, remedies are part of a very important discussion every time a tutela is decided. And the court has developed doctrines to establish the level and the kind of remedies. So, for example, one doctrine is the doctrine of the unconstitutional state of affairs. So the court says, if tutelas show a structural problem that compromises several agencies and that reveals a clear lack of budgetary resources to address the problem, it is not reasonable to order the government to solve the problem in a week. It's impossible. So what the court does is to declare a state of unconstitutional affairs. So the court looks at reality, not at decrees, resolutions, what is really happening. Declares the state of unconstitutional affairs and characterizes the structural problem, and then gives the government an order with a lot of time to solve the structural problems. So this is a creative kind of remedy. It's strong in the intervention because it censures unconstitutional state of affairs, but then gives leeway to the government to try to address the problem. But sometimes the court doesn't go as far and basically says there is a need for a plan or a need for a policy. Always the court protects in the individual case the rights of the person that utilized the tutela. So even in a case of the right to housing, the court may say there is a problem of violation of your individual right to housing, orders the protection of the individual right, what is needed in this case, and then complements the order with the need for a plan or a policy. Sometimes the court gives a loose order, sometimes it structures the order. Then the court, when the problem is very complex, the court has added follow-up. So the court says, here is the decision, but in 1 year, there should be a report to the court to see what is happening. And when the report arrives, the court can start adjusting the orders originally given. So, for example, in housing, the Minister of Housing can go to the court and say, I tried, it's too difficult, I still have not solved the problem. I can do this, but I cannot do that. Please, I request the court, do this kind of change in your order. And the court considers, listens to other interested organizations, for example, that work in housing, listens to the ombudsman, listens, and after listening to several perspectives, makes a decision. So the order can be adjusted in an incremental process that is aimed at having a final protection of the fundamental right of a group. So the court has worked this way. Sometimes the order is very simple. It's just resolve this petition concerning a social right, and that's it. In abstract judicial review, that is when the court judges the constitutionality of an act of Congress in the abstract, as happens in Germany, for example. Also, we have that in Colombia with actio popularis. The court can modulate the effects. The court can say, this, for example, this law is unconstitutional, but I will give Congress 1 year or 2 years to solve the problem. This is what happened with the same-sex couples case. The court said, the civil code does not provide for same-sex couples marriage. Should I, as a court, impose marriage for same-sex couples as the civil code provides for? No, it's not my role. I give Congress a delay to adopt a statute providing for same-sex couples marriage. But if Congress does not adopt the statute, then the civil code will apply. So there is always a way to imagine a remedy that unleashes a technical, regulatory, political process.
Yes, Sandra.
Thank you so much for the fascinating talk. I think that, so I have issue that I thought could arise would be that of a backlog of cases, because that's what we're facing in India in terms of the number of cases being instituted in the Supreme Court have become so many that it's very difficult to deal with generally. And related to that is a similar concern with the judicial, that is the idea of the polyvocality of the court. So if essentially that it's a similar problem in India as well, where the whole Supreme Court doesn't sit as one bench. It sits as 2 judge benches or 3 judge benches. And what lands up happening is that there's incoherent jurisprudence that gets developed. So it becomes very difficult to study, and that's a problem I'm facing right now. It becomes very difficult to study and pick which cases to look at in terms of what's binding and what's not. So if you have, for example, sorry, my voice is a little, but if you have, for example, two decisions by different judges dealing with with substantially the same matter brought by 2 different people, then which one would bind? So that's the question about the judicial. But the second question, and I'm sorry, it's the last question that I had, was in relation to judicial, the separation of powers question, sort of hinted at here as well. And this reminded me of you talked about responsive constitutional adjudication. So essentially, if the role of the court is to direct the appropriate institution to perform, which is what I understood as the to-do function, what happens when that political institution doesn't perform? Or alternatively, what happens if that political institution works in a majoritarian manner by its very nature and thereby excludes a particular political group from participation in the first place? So in India, we have the same, like the issue that I'm thinking of is the decriminalization of homosexuality issue that has been going on. And in 2013, the Supreme Court basically passed this judgment that was quite a regressive judgment, where the operative part of that was that they sort of took a step back and they said that we will not strike down the legislation that criminalizes homosexuality. Instead, we will say that it's the domain of the legislature to look at reconceptualizing the law and thereby repealing it. And then after that, because of the fact that the legislature was because of our current government setup, because of the fact that there is a particular way in which the majority work, the legislature, that never happened. So as it stands, the statute book still has that regressive provision. So how would the court deal with an issue like that, where there's no response from the institution that says should respond?
Thank you. A lot of questions. So first, concerning the number of cases, and tutela must be decided in 10 days. So each judge, in first instance, has just 10 days. Then there is an appeal, 20 days in appeal, sometimes it takes longer. But then the court decides what cases to select. All tutela decisions in the country are sent automatically to the Constitutional Court, and the court has total discretion to select. So, citizens receive a decision in 10 days, that's good, but really the final ones, the most important ones, are rendered by the court. And the court can cumulate different cases and can select with total discretion which cases to decide as the court that renders the final decision. This has created a system in which there is a lot of cases, but the Constitutional Court is always on, is not submerged, is not submerged, can manage the amount of cases. When there are contradictions, the court can select the case and reiterate the precedent. So there are kind of decisions, I would say a lot of the decisions rendered by the Constitutional Court usually are decisions saying the lower instance judges, you should follow the precedent. It's an easy case. Then come the most difficult situations, which are the situations in which there are contradictions between the different chambers of the court. It can happen in the Constitutional Court. In these situations, there is a mechanism to go to the plenary. And so the plenary, which is composed of all the justices that work in all the chambers, renders what is called a unification decision, and then all the chambers have to follow what was decided by the plenary. Of course, there are still contradictions in the system. It's impossible to solve all of them, but there are provisions to minimize these contradictions, or at least to solve them within several years. They cannot stand forever, these contradictions. Then the other question, what to do when there is not a response by the executive or the legislature, how to do. So there are basically, to sum up, three mechanisms. One is contempt of court. When a clear order has been imparted and the order is not implemented, there can be contempt of court, is decided very quickly, and is a serious matter. It's a serious matter in Colombia. Ministers have been under contempt of court. Presidents of universities have been under contempt of court. Important officials of bureaucratic agencies. So second mechanism is follow-up. So when the court anticipates that it's a hard case, it's not easy to respond for, the court can establish reports, and in this way be its own implement. The court implements its decision. It's not contempt, but implementation and follow-up and monitoring. The third one is a remedy in which the court establishes a default solution, as I mentioned, in the same-sex cases. For example, in the Indian case, what would have happened in Colombia if the court decides not to strike down the legislation, say it's unconstitutional, but Congress should amend it. But if Congress does not amend it in 2 years, then there is a default solution. And this default solution is designed by the court. So, in a way, the court anticipates that perhaps there will be disobedience or just deadlock, because the issue is so complex that will be deadlock.
Yes, go ahead.
This has been an incredible talk, especially like being a young sort of lawyer coming from South Africa, a jurisdiction where there's so much contestation about the constitution happening right now, and I was quite intrigued by sort of what is the underlying sort of feeling of the Colombian people to treat or see the constitution as a revolutionary instrument in of itself. Because there's a lot of conversation happening in South Africa where there is sort of a rejection of a constitution as a liberal sort of process that has left the poorest and the most disadvantaged and the most marginalized behind. And I'm just wondering what kind of, you use the term sort of imagination, what kind of imagination do us as young lawyers now looking at the current text that we have, but also considering the conversation that is happening, to really bring that energy back of seeing the constitutional process as an act of revolution. Because in a lot of ways our constitution is amazing, but there is something that's missing. And I'm not sure if I'm articulating this correct, but I'm just wondering what is it about the ways in which the Colombian sort of judiciary is articulating itself that makes it sort of like seem, or that creates this perception and this belief in it as a revolutionary sort of institution, more than a liberal sort of like institution that protects only the interests of the middle class, only the interests of specific, people.
Very tough. I'm very, very important question. Very tough, very difficult. I am not well aware of what is happening in South Africa. I have learned a lot from Kate, who is my teacher in this respect. But in general terms, what I see is that there is a fundamental difference in the constitutional moment. In South Africa, the new constitution, the constitutional court, and what followed was a change, a total change of regime, with Nelson Mandela as a leader of the transformation. So if you want, what you have is that all the three evolve worked together in the same direction until something happened. I don't know when. You mentioned that there has been some tensions. Okay. In Colombia was totally different because, let's say, the disadvantaged, the discriminated, the persecuted, the excluded did not win. So in South Africa, apartheid ended, Nelson Mandela became the president. In Colombia, if you want, Nelson Mandela never became the president. Never. So the political process didn't follow at the beginning, after 1991, didn't follow the same direction. But there was a backlash. There was resistance. And this explains why in Colombia the judicial power had a space to intervene and was pressed to intervene. But there were reactions at the beginning. At the beginning, in Colombia, judges didn't want to do that, were not happy with so much work, were afraid of interpreting fundamental rights. So it was not easy. I would say that there's a second factor, which is a tradition of respect for what the judges do, because we had a 100-year tradition of judicial review. So in Colombia, when a judge intervenes or the court renders these various activist decisions, it's not strange. We say, well, it has happened before. It's part of governing with judges, if you want. It's in our DNA. It's in our political DNA. So it doesn't generate a reaction. Third factor is the justices that started at the beginning. There was a transition court of 1 year, and this transition court was composed of very imaginative justices that were there for 1 year and said, what I am going to do in 1 year with this new constitution. They decided a lot of very important things, and the justices that followed, didn't react strongly.
Thank you very much for your presentation. I have two questions. You just mentioned that the judicial decisions and the political process never followed the same direction which follow the judicial decisions. But whether you ever experienced any pressure from the politicians and the mainstream cause, and how it was possible to remain sovereign in this sense and independent by the decisions. And my second question is, it is absolutely unique what you're describing concerning the judicial strategies of protection of those in poverty and most vulnerable groups. And my question is whether the judicial activism of the Constitutional Court in your country influenced the other judicial systems in Latin America, for example. Thank you very much.
Thank you very much. Well, in Colombia, there is always a tension, a controversy between the court and the political process. Sometimes this controversy leads to constitutional amendments to overrule the court, and the court accepts to be overruled. I could mention several. Unless it is an amendment that is so critical that affects the structure of the Constitution. We call it the essential elements that define the identity of the Constitution. There the court intervenes and said, no, this cannot be changed. But the court doesn't present herself in the political arena as having always the last word. Nobody has the last word. It's a process. It's a process, and the court contributes to build a consensus, if you want. Secondly, the independence of the court has been challenged, has been attacked, but there are a lot of mechanisms to preserve the independence of the court. Mainly, rules concerning salaries, concerning the prohibition of receiving from the executive a post after the judge goes out, has to wait for a while. The 8-year terms helps to that paradoxically, because the Senate may be angry with the court but has the illusion of packing the court in 8 years. And in 8 years we will put justices that will do what we want. So it creates a kind of toleration of the political process. And sometimes the amendments to the Constitution to overrule the court generate a political debate that is different, and the amendment is not approved. So, for example, there have been attempts to overrule the court concerning euthanasia. Not approved. I could mention several others. So this is, and I would say also the judges are independent because of their character. The real independence of a judge resides in the judge character. That's the key thing. And fortunately, most of justices in Colombia have independent character. Concerning the influence in Latin America, yes, the 1981 Constitution has been influential, the Constitutional Court has been influential, but each Latin American country is very different. We are a continent, we speak Spanish or Portuguese, but each country is really very, very different. I would say that some doctrines of the court have been looked at in different countries. For example, this doctrine of the unconstitutional state of affairs has been interesting for some countries in Latin America. But I would highlight that each Latin American country is very different.
Well, we've had a really fascinating evening, and thank you very much indeed, both to Manuel and to Octavio and to Sandy. I'd like you all to just join me in thanking them.